me a thumb up. Hi, everyone. Yes, good afternoon, everyone. Thanks for joining us. Today, we're going to focus on topics, as you can see on the banner, winding up and bankruptcy. Today, we have the similar panel before. We have, let me introduce the panel. Number one, Dennis Lim from Jason Kong & Co. He's majored in litigation, so it is the right person to share. We have Mr. Paul, from Paul and Partners. Yes, he himself is also a litigator. Been handling matters pertaining to the winding up and bankruptcy as well. Moving on, and we have Mr. Satya from Satya Lee and Co. Yeah, he himself is also very active in court, moving around, handling litigation matter as well. So thank you, gentlemen, for joining us today.
Thank you for having me again, Jason. Satya,
Yeah.
Hi, guys.
Yeah, how's everyone?
Thank you, Mr. Jason.
Yeah. So I believe the audience is joining in one by one. We can see people are joining in, and we apologize for the confusion that initially we start at 2, but then I understand everyone wanted to divert the attentions to the Prime Minister, so we will and then we will understood that we will move on to at 3 o'clock. So we start Mother's Day. So before we wish everyone happy Mother's Day, and the topics today, it is quite crucial because of the current positions of the society. Many people in business might facing, for those who are operating as a Sendirian Berhad, might facing some winding up issue. For individuals who operate as a sole proprietor or a partnership, they might also face a bankruptcy issue. So the audience might want to know if they fall under this ambit of winding up and a bankruptcy. I believe the audience wanted to know, the proceeding of getting themselves bankrupt or wind up the company. How do they go about it? And I think our guest panel today will be able to share with you, because I believe all the lawyers today themselves have been personally hands-on on some of the winding up matter as well as the bankruptcy proceeding against the perspective of a plaintiff and also perspective as a defendant. I think the panel here will then share with you on both sides of the coin. Moving on, before we start, we have to do some housekeeping work. The talks will usually go for half an hour or 45 minutes. It depends on the panel sharing, and that will be part 1. So in these sessions, part 1 will then also split into 2 parts themselves. So we will then talk about individuals. It's more hands-on to individuals, related to individuals pertaining to bankruptcy first. Then we're moving on to the winding up. So that will be part 2. After having discussed all the topics today, we will then open to the floor for questions. So in this case, the floor, it will be online. If you are looking at the live now, you can see there are comments column. You can type your questions over there. Then I will be the moderator to read out the question. Okay, without further ado, I will then start off with the topics on bankruptcy. Now, the bankruptcy issues is it is pretty crucial. It is related to individual. Okay, the audience out there wanted to know. Currently, people are facing financial difficulties. I mean, it will then relate to bankruptcy if they couldn't afford, or they will then facing the financial hardship and so on. They will then lead them to bankruptcy. So perhaps one of the panel here can share with us what is this bankruptcy about, and you can just brief us. What is the maybe you can explain to us what is it bankruptcy about before we go to the proceeding, before we go to the court, and then briefly you can just share with the audience today. Yeah. Anybody who,
Okay, I can start first, Jason. If
yeah,
just a
okay, you,
basically a general uh, idea on bankruptcy is that first you need to be insolvent first. So you're not a bankrupt yet. So
yeah,
you are only a bankrupt once you are unable to pay your debts. You are insolvent. During the insolvent time, you can dispute if there's a claim against you for any monetary money. So in the event that you are unable to pay your debts, then they can apply to make you a judge you a bankrupt. They proceed a petition, bankruptcy notice first. A general
I see.
idea.
Okay. So, from Mr. Paul have told us that you have to commit an act of bankruptcy. So I believe it is to failure to respond to a bankruptcy notice.
Correct.
Yeah, there will be a progress in terms of heading to court and so on. So now I think the people then the fact that they couldn't afford to pay. So what do they expect after this? What do they expect? Are they going to receive a summons, or after the letter of demands or bankruptcy notice? Then the people will wanted to know, how thereafter what's next? How do lawyers make us bankrupt then?
All right. Sorry if I may
Yeah,
just
yeah,
add in
sure.
on what
Yeah,
Mr.
Dennis.
Paul has
Can.
Right.
pointed out. Okay.
Yeah,
First and foremost, to everyone out there, a
yeah,
bankruptcy proceeding can only be taken if the amount that is owed by the debtor to the creditor, which is the minimum threshold, is at least a 50,000 ringgit. So, like Mr. Jason has pointed out, he used the phrase an act of bankruptcy. So in layman terms, an act of bankruptcy basically means that it's the scenario where the debtor is unable to afford to pay, which basically means he doesn't have the financial capacity to pay the debt. At that point of time, he's deemed to committed an act of bankruptcy. Okay, Mr. Paul has pointed out a few points. I just wanted to add in on it. Nothing much, nothing less. Just bear in note that only the court of law can declare a debtor as a bankrupt via a bankruptcy proceeding. The most common scenario is where the creditor has obtained a judgment against the debtor and a bankruptcy notice has been issued against the debtor.
all right.
There is a time limit imposed once the bankruptcy notice has been issued. Once there's a default by the debtor, then the creditor himself will proceed with the creditor petition.
Yes.
Yes, thank you.
All right. Thank you, Mr. Dennis. Okay, right now, we talk about this huge topic of bank. I make adjudicated a bankrupt person. Uh, is it a saving mechanism that I don't have to pay the debts, and what next after that? I believe the insolvency department will step in, right? Or how do they handle my affair? What is the disadvantage of being a bankrupt person? Perhaps I think the audience wanted to hear. Can I still operate a business? Can I travel? All those stuff. I think people wanted to be certain on the capacity being a bankrupt. So anyone can share with us on this point?
All right. As a bankrupt, you will have what you call it the rights as a bankrupt. You have a limited rights. You're not allowed to travel overseas with your passport surrender unless you get the specific approval from the DGI. In this case, the Director General Insolvency. All right. First and foremost, before I proceed, I'll say that once you are declared bankrupt, all your property will be vested with the DGI himself. So they will sell them, and the income will be distributed among the creditors. However, certain assets can be sold, which is like property you held on trust. Procedure
Mm.
on, you are as a bankrupt, you are not allowed to hold any management position. You can't be an adun, a YD, or anything, and you can only maintain one bank account at a certain point of time and one credit card with a limit of 1,000 ringgit. I believe at every 6-month interval, you have to submit your income and expenditure accounting report to the respective relevant individuals. And you also have limited legal action.
I see.
Yes.
I think the rights to defense and right to sue also will be then limited. And
Yes,
also
subject to the approval from the DGI, Director General of Insolvency.
Yes, yeah. Yeah.
So to add on
Satya.
for what Dennis
Yes.
said, Mr. Jason.
Yes, Satya. Yeah.
If anyone want to if they want to initiate a suit or they want to defend the suit, they have to get a sanction from the DGI. So they have to write into the DGI, say that these are the case, and they require a sanction from DGI for their lawyer and for them to appear in court to defend or to initiate a suit.
Yes, I see. So now we all know if a life of being a bankrupt, there are plenty of disadvantage, and I believe the people who are heading to that directions wanted to maybe ask for an escape route. Is there any way that can save me or rescue mechanism in place before I've been adjudicated a bankrupt? If there is a rescue mechanism in place, other than appointing a lawyer to defend the bankruptcy suit and so on, is there any other way to approach the settling the judgment sum? So in the context of bankruptcy.
Right.
Yes,
yes, Mr. Dennis.
Right. Okay. If I may, instead of we looking at this whole context or perspective as a rescue mechanism, there are certain conditions or prerequisites that ought to be fulfilled before this bankruptcy proceeding can be initiated. First, you have to look that does the debtor, is it domiciled in Malaysia? Second thing, the debt must be for the liquidated sum. It cannot be for a certain sum that cannot be verified the source of it. I think the most important thing is the act of bankruptcy must have committed or occur within 6 months before the creditor petition is presented to the DGI or the courts. The almost thing that in all this entire picture is that what are the current position of the debtor? Is it because he sued because of is he a guarantor? Because after the amendment in the Insolvency Act 1967, social guarantor themselves they have this what you call it, a special privilege, which is the bankruptcy petition ought not to be commenced against social guarantor, because in the past few years we have seen a lot of abuses from the creditors where they take the most easy route. Once they could not find the direct borrower, they go against all those guarantors, especially the social guarantors who have guaranteed the loan. For the example, you take educational loan, hire purchase loan. But now, after the amendment, all the social guarantors are exempted. But we also have another scenario where guarantors other than social guarantors, which is for a different type of cases. But this, you have to get the creditor themselves, they have to get the leave of court before they can commence the bankruptcy petition against these other guarantors, which make the case much more perplexed and complicated. In a way, it guarantees the rights of the guarantors and protects them at the same time. Thank you.
Because thank you, Mr. Jason. To add on to what Mr. Dennis said, that was the amendment for the new law. Because prior to the amendment of bankruptcy rules and act, so now it's no more bankruptcy act, it's known as Insolvency Act. There whereby the bank or anyone, I mean, especially we can take an example like hire purchase case, or facilities agreement has been breached. Especially, but usually in the hire purchase case, I mean, a very good example, whereby before the amendment, the bank usually take an action against the defaulters and the guarantor. Because usually this guarantor will come and sign in as, most of it is just helping as a friend or family members or close friend to help them to secure the loan. And because prior to the old because before the amendment, it's totally it'll be unfair for them because they also will be declared bankrupt. So and you can see in the like the hire purchase or so on. But with the amendment of new law, at least is that we protect the interest and the guarantor, which is I think is a very good amendment because the law should punish those who defaulted the payment. So with
Yep.
the new amendment, I think it's very fair and it's very fair for you to punish the defaulters. If in order like Mr. Dennis said, if you want to bring an action against the guarantor, you have to get a leave of court.
Yes.
Thank you, Mr. Jason.
Yeah. Thank you, Mr. Satya.
And
Mr. Paul, you want to
Jason
say something? Yeah.
Yeah, I was just add on of what Mr. Satya and Dennis have talked about.
Okay, sure.
The new Insolvency Act also, like both the panel have mentioned on the guarantor. Social guarantor, of course, they has a privilege. They exempted to be, but respect of guarantor itself, beside the leave of court, it also protect them as a last resort for the claimant to sue for guarantor. It's a last. They can only go against the guarantor on a last resort situation, and with the leave of court, and also with this new Insolvency Act, there's also a voluntary arrangement before a person is to have a bankruptcy on him, bankruptcy notice or any claim to declare him a bankrupt. To avoid that, he himself actually can propose or apply for a voluntary arrangement to appoint a nominee, accountant, lawyer, maybe then to get an interim order so that he will not be sued to become a bankrupt. They will discuss with all his creditors on any arrangement payment. If it's agreed, then it is binding. So he need to go through the court as well. But there is this options for him for a bankrupt person before he become a bankrupt, he become a bankrupt, to apply to seek into this voluntary arrangement. You see, so this is one scheme. Second is that he thinks that he is unable to pay a debt. He's burdened with a lot of debt now. There's other agency that can manage his money, like AKPK. So basically, it can manage his affair for them, arrange his debt. Of course, there's a condition to be fulfilled, like this agency, the government agency, which they will propose to restructure your debts, your financial, manage your finance for you. So there's another option as well. That's out there. Before, if you foresee that you're going to become a bankrupt, you face all that. These few options that you may have. You see, for the person.
Thank you, Mr. Paul.
Right.
All the panel who share, we did touch on being a social guarantor. You know, the status of being a social guarantor is pretty much secure in a way due to the amendment of the recent on the Insolvency Act. And further to that, there's also voluntary scheme of arrangement in terms of settling the debts, and also they are a private entity out there by the name of AKBK, be able to assist anybody who heading towards the bankruptcy route. But I think anybody right now, as we speak now, we know the CMCO has been extended, further extension until 9th of June. Now, I believe during this time, whoever who operate as a sole proprietor or a partnership in a business, you might also consider the various monetary availables in the market, whether it's Picasso, or the pre-Hatin effect on pertaining to all this mechanism. you can exit exhausted all the avenue that you can before the last station where we say you then face a bankruptcy if you couldn't, survive in terms of financial position, but not to slacking on all the available avenue that you have. So now I think because of this 2 more weeks extension, I believe people out there can actually look at all this avenue, to exhausted all the avenue, then we look at the bankruptcy. So you might not want to jump to the conclusion at this moment. There are plenty of opportunity before you being adjudicated bankrupt. Now, I think we have shared enough on the issues of bankruptcy, and we then move on to winding up. Okay, while we referring to this topic on winding up, it is only related to Sdn Bhd. So unlike the sole proprietor or if you are able to, or your company will be insolvent, you will be potentially be wind up. But I believe there are some recent amendment on the winding up law. The SSM have put up some latest development. I think Satya, you want to share with us on the latest amendment?
Yeah, sure. Thank you, Mr. Jason.
Thank you, Mr. Satya.
Okay, regarding for those who are outside there, for viewers, just for your information, usually the winding up petition is only for Sdn Bhd or private limited companies. Okay, before the old law before the Insolvency Act was, if you have a 500 ringgit, you can wind up a company. After the Insolvency Act was taken place, the law has been amended and gazetted, the threshold sum was increased to 10,000. Then during this, when Malaysia have implemented MCO due to the COVID-19, the law has been amended and gazetted, and the threshold has been increased from 10,000 to 50,000. And before we initiate a winding up petition or we file in court and we take against any parties, usually we will serve a notice. The old laws usually said that within 21 days they should reply to the statutory notice. But due to the amendment during the MCO, it's been the government have gazetted and has allowed the notice for other side to reply for 6 months. So basically now the statutory notice will take place for 6 months. Therefore, 6 months for them to reply, and after that only the people, they can initiate, they can start a winding up petition against those to recover the judgment sum. Usually, the winding up will be a private limited company will take an action against another private limited company. So I think this is due to the COVID-19 situation, whereby a lot of the business owners, especially like big companies or private limited companies, has been affected. So I think this is one of the move by the Malaysian government to protect them, so that the 6 months, hopefully by 6 months, they can recover some of the money, or they can negotiate with the other party to come to a conclusion without going to winding up. So I think it's a good move for those private limited companies because you have a negotiation duration for 6 months.
Yes, thank you, Mr. Satya. Now, having said that, it is more pertaining to the compulsory winding up, where one party commencing an action against the other party. But there are also another type of winding up, which is voluntarily winding up. So instead of waiting for people to sue, they themselves have done the calculation. They have for the next 6 months. So in terms of voluntary winding up, maybe any of the panel can just share with us. I can't wait 6 months myself. The company would have to close it. So in that case, is there any chance that I shall then proceed to wind up the company? Or there's a term called voluntary winding up?
Okay, maybe I can start first, Jason.
Yeah, sure. Mr. Paul,
Yeah.
yes.
A general thing on voluntary winding up is that there must be it may be become from the company itself, the members or the creditors. For the members, they will pass a resolution to state that for this 12 months, within 12 months, uh, their company is bad. They they have to need to file to wind up. So of course there are a few conditions need to be fulfilled during if you are proceeding with voluntary winding up. First, resolution within the members, and the members also have to come up with a declaration of solvency of a sum to be paid within a certain month, within the 12 months. So then the creditors as well, if the members can't provide that, then the creditors can apply for to wind them up, voluntary winding them up. You see, there
All
will
right.
be a meeting with the creditors as well during that time. You see.
Thank you, Mr. Paul. Thank you. Now, if a company who, now we know that there will be a winding up notice, and of course that I have got to buy some time due to the recent amendment that I have 6 months. Uh, on the other hand, I could have just wind up myself. That will be by way of wanted to ask: is there any rescue mechanism in place, which I can actually, survive of this pandemic? The company wanted to pay all these creditors. Is there any way, instead of heading to the wind up direction, I mean, along the way, is there any rescue mechanism in place that a company can consider, without being a wind up? Perhaps I think Dennis can share with us on the saving mechanism. The company wish to know, I guess. Yeah.
All right. Thank you for allowing this
Yes, Mr.
opportunity.
Dennis. Yeah.
I can't go on lengthy about this, but I will try to summarize in a most simplest way for the folks out there to understand it. Essentially, there are three corporate rescue mechanisms which has been prioritized or has been brought to light due to the amendment to Companies Act 2016. We have the scheme of arrangement, which I think the folks out there has been heard before. The judicial management, application for judicial management, which has been a trendy dispute resolution in recent years. Last but not least, we have the corporate voluntary arrangement. All right, first and foremost, if we look at these three, I think the folks out there, I can't delve into much details on this, but I would say that out of these three, the most current effective, if I'm wrong, the most effective one is the application for judicial management. Why? Because once the companies in debt, the debt ridden company, they can proceed to file an application to the court for this judicial manager to be put in charge of their the affairs of their management. Once the application has been filed, a moratorium is imposed on all the, whether is it future or ongoing proceedings. Because I in my own practice, I've encountered one scenario where I was one of the parties affected by this moratorium imposed on the companies. This moratorium itself, the sole purpose of this moratorium was to protect the company from all the ongoing suit. In the meantime, pending the disposal of this application for judicial management. So out of all the three corporate rescue mechanism, you can have, okay, I will just delve into the other one. Take a scheme of arrangement. It's more like it's more a court supervised mechanism for the reconstruction and restructuring of debt of companies. But bear in mind that to initiate this scheme of arrangement, the creditors themselves have to conduct a meeting with all these directors, and a 75% vote has to be obtained from creditors. This all this has this rigid, it has it is much less effective compared to the application of judicial management, because most company, imagine you have sharks, debtors waiting at the outside of the door, trying to enforce all their judgment against you. So The application of judicial management out of the three will impose a moratorium on all the future or existing litigation proceeding against the company. All right, thank you.
Yeah, thank you, Mr. Dennis. Okay, how about others? Other panel, do you want to add on to what Mr. Dennis have just said?
But just to add on to like Mr. Dennis said, there's a saving mechanism which are not many people are aware for winding up. But like Mr. Dennis have highlighted to the viewers, saying that the most effective is judicial management. But I think it's not an easy for them to obtain a judicial management. There's a certain threshold to be fulfilled for the respondent to show in order for the court to allow a judicial management application to be allowed for the respondent. That's all, Mr. Jason.
Mr. Paul, you want to say something?
Maybe just to add on a little bit, like Satya said, it's not that easy to get a moratorium or judicial management. If the court do allow, there will be a condition as well. There will be a time period as well for that, and for the parties to hire to what they have agreed on this moratorium. Between this moratorium period, they will have to do, the company will have to do something as well in respect of the accounts, everything. So there will a period as well. The court will give a period. Then they will have to reapply again after the period lapse. It's not that there are conditions from the court as well, if it's allowed.
Yes. Thank you, Mr. Paul. All right. So far, we have basically touched on both areas of bankruptcy and winding up proceedings. And we also know that, this is not end of the world when you have been approaching either as a there are ample of saving mechanism or rescue mechanism in place that you can actually, consider taking certain steps they consider taking. So it's always advisable to engage your lawyer, talk to your lawyers and, looking at plenty of which are the suitable step that probably your lawyers will suggest you to take, instead of just head on to the winding up and get your company wind up. Probably there are plenty of options out there. Now, thank you all the panel who share with us from the introductions to those topics until all the technicality has been shared with all of you. Now we are moving on to part 2 of the sessions.
To just add on just one part. I think the viewers will be very they want to know what's the time limit, what's the duration. If just say they already filed a bankruptcy.
I think Satya raised a very good point here. Let's talk a bit on the bankruptcy. Yeah, Mr. Satya, go ahead.
Because the company, as we know, the company have 6 months for them to reply. 6 months since the time the statutory notice has been served. But for bankruptcy, because it's not been amended, and perhaps especially the individuals, because usually the standard cases will be the companies are still very not much cases compared to the bankruptcy against the individuals, because 50,000 easily can make you a bankrupt to initiate proceedings against you and to declare bankrupt. Maybe folks outside there will be wondering how long is the duration. To be fair, it's case to case basis, and depends how complexity of a case. That's my personal experience. I have defended a client from she was supposed go for last creditors petition was on July 2017. Sorry, September 2017. There was supposed to be hearing of creditors petition, but she was not represented. So I represented her. So I managed to file a stall there, but because the case was initiated based on the judgment in default, which they obtained in another high court. So I filed a stay, and there was some cost papers has been filed there. So after that, I stalled again. Then I filed an application to strike out the bankruptcy notice and creditors petition. But my application before the senior assistant registrar was allowed. But subsequently, when the bank appealed to the High Court, to the High Court judge in High Court judge in High Court judge, and the High Court allowed their application, and whereby I filed a stay, but the judge did not allow my stay. So there was about last year December, last year September, end of September, they managed to get adjudication order and receiving order against my client, which declared bankrupt. But subsequently, I appealed to court appeal, and I managed to set aside the High Court judgment, and I managed to save my client from bankruptcy. So this is my personal experience. So it can be a case-to-case basis, and depends on the complexity of the case. Just my personal experience to share the viewers.
Thank you, Mr. Satya. Thank you. Yeah, I think Mr. Satya have brought out a very good point that people who wanted to know how fast I will be being adjudicated bankrupt, and being the plaintiff on the other hand, who wanted to know how fast they can get back their money or make the other person bankrupt. So likewise in the company as well. How fast do I make a company wind up? I mean, right now it's pretty certain in terms of timing. You will have a 6-month leeway in place. Yeah, but as far as the bankruptcy or winding up is concerned, I think it will then depend on the case-to-case basis. So you can't have a blanket rule that things can be resolved in 3 months, 6 months. It will, like what Mr. the court diary, the competency of your solicitors, everything is in place. Now, I think there are several questions on the list. So shall we move on to the part 2 of the talks, whereby we will then address questions that provide from the comments column. Let me see. Okay, there is this questions about it goes like this. What are the links between criminal system and administrative system in case of fraud bankruptcy? So I'm not sure whether the panel be able to read the comments here. The questions goes like this. What are the links between criminal system and the administrative system in case of fraud bankruptcy? System in Malaysia context will be civil system, I guess, right? Because it's from we practicing point of view, it is either civil or criminal, right? So I believe the questions goes to where there is any link or not. Perhaps fraud bankruptcy, it is the questions. What is the link?
I'll try to address that. I'll try my answering the question.
Can.
For basically, for bankruptcy, usually goes by civil in nature, right? And your property will be vested in the DGI insolvency department. So when you are judged bankrupt, they will have an examination meeting to know your affairs of your estate. You will have to tell them what you have owned, what transaction you have done. They can investigate on your transaction until I think back to 5 years. Back 5 years. So in between, if there's an element of like you are trying to avoid paying your debts, siphoning money out, then they can trace back. The court can, in civil nature, they can trace back. And during the petition period, 6 month notice, if there's a indication that you have tried to change your property's name to your wife's names, then in the sense of element of fraud, not to pay the the claim, then they can trace back. It's civil in nature, but criminal-wise, of course, depends on how. I would say it depends on the case itself. Whether really there's a criminal nature involved, you need to make a police report, then to follow up from there. Different branch as well from there.
Thank you, Mr. Paul. Yeah.
So just to add
Yeah,
on
Mr.
to
Satya. Yes.
so what Mr. Paul said, the criminal side.
Yeah.
If the DGI or the respondent, I mean if someone usually it'll be a DGI's work. If DGI have found out that this particular person have transferred the property by fraud during the bankruptcy proceeding, they can take action against them by, like Mr. Paul said, by lodging a police report. Then whether they'll be charged because for criminal fraud is entirely up to the Attorney General. Police will do an investigation. Upon investigation, if they says there's a serious fraud involved during that period, they can be charged in court for criminal offense. Back to you, Jason.
Yes, we further moving on to the next questions is Malaysian bankruptcy proceeding conditioned to a domicile or citizen of the debtor? Is it enough that a Malaysian citizen who live abroad has asset in Malaysia to open proceeding against him in Malaysia? Right, the question goes like, is Malaysian's bankruptcy proceeding conditioned to domicile or citizen of the debtor? Is it enough that a Malaysian citizen who live abroad has asset in Malaysia to open proceeding against him in Malaysia? Yep. So this is the Mr. Joshua questions. Joseph questions. Yeah. Anyone can take up the questions and answer.
Okay, maybe I can. I'll start off.
Sure. So I think it will be.
There are a few conditions if you want to start off with the bankruptcy and notice. Of course, depends on. Depends on the debtor itself as well. Whether the debtor, it's all on the debtors. Whether the debtor is domiciled in Malaysia, and it's not more on the claimant. It's not more on the claimant. Basically, it's on the person that owes you the money. Whether he's in Malaysia, he has asset in Malaysia, then you can proceed with this bankruptcy notice. Not necessarily on the claimant. He may be from overseas, but it's all on the debtors. Hope that answer.
I mean, to just add on to what Mr. Paul said, usually in some cases where the judgment sum they're 50,000 above, they try to file a bankruptcy notice against these particular individuals. But unfortunately, they can make him bankrupt, but they won't end up getting anything, because end of the day, they will notice that none of his properties are vested in Malaysia. Then there's a cases whereby also where they don't have any property registered their name in Malaysia, all in overseas. And plus, usually in any event, I think the solicitors will do some groundwork to check whether you have any property been vested in Malaysia or not. Because because it will defeat the purpose and time if they have taken an action against a person, but they have because the bank account can be transferred anytime. Usually bankruptcy, they'll go for immovable property because changing and transferring a name might take some longer time. So if they found out if there's no property, then it's defeat the purpose. But in any event, usually the lawyers will do some groundwork to do some search through medium to make sure that make sure that they have some property. So it's a word for them to initiate a bankruptcy suit. If no means, they'll go for different execution against this particular person if they can't unable to trace their property in Malaysia.
Yes. Yeah.
And also depends on whether they have business in Malaysia as well. Then there's an invitation to proceed as well.
I think the question is also related to jurisdiction, the course of action accrued and whether it is happened in Malaysia or overseas. So whether the contract was actually signed and breached, whether it is happened in Malaysia. If you're talking about taking actions in Malaysia, it has to be several conditions in place. For example, the course of action accrued here. Bankruptcy proceeding, it is an enforcement of judgment. One of the enforcement of judgment. Question is whether you can enforce here. Of course, if you can, if there is a property in place in Malaysia. Yeah. Okay.
Jason, there's some. I think there's Mr. Joseph have written the question. He have mentioned that, thank you. I meant Malaysian living outside Malaysia but as assets in Malaysia. Can he be bankrupt in Malaysia to take away the assets?
If I may just add on to this.
Mr. Dennis, yes. Sure.
Okay, one of the prerequisite for a bankruptcy petition is that the debtor itself, he has to be domiciled in Malaysia. So if the debtor is not domiciled in Malaysia, there's a gap in the requirement itself. So the court will be considered if the debtor is not domiciled in Malaysia, even though he's a citizen of Malaysia, but he's not domiciled in Malaysia. So the question is, can a bankruptcy petition actually initiate against this living abroad nation citizen?
So, but to just add on to Mr. Joseph question, I think it depends. If he has been just say in one of the out of the Malaysia out of just say Singapore, for example, if they have obtained a judgment against him and they found out there's a perhaps they can use that judgment to be enforced against him in Malaysia. So that's where the reciprocal comes in, and it depends on which country has been obtained the judgment against him in order for them to enforce the judgment in Malaysia.
Yeah. So I believe as far as the enforcement of judgment is concerned, you can actually cross-border jurisdiction, get the judgment registered in that country, and you can we come across a situation like this as well. Okay, moving on to the next questions. That will be this: the ongoing crisis will definitely impact M&A stroke winding up proceeding, pre-completions undertaking, warranties, due diligence, time, schedule, and so on. Any thoughts or advice? So I believe this question is directly giving a hint on the contract, the assistant contract that parties has been signed. There are several warranties or obligations in the contract to be fulfilled and performed. So it is a very general question. Basically, what is the panel have any thought or advice pertaining to all this? Having a crisis in place, unfulfillment of contract, unfulfillment of warranty or undertaking. So what is your thought or advice? Perhaps you can actually look at the postpone the performance. It's ring a bell, right? The force merger thing.
Depends on the agreement. I would say all depends on the agreement. How is it drafted? Whether this force majeure is in place, is drafted there, and if there's not, of course, taking to this MCO, it affects everyone, the whole country. So
yes,
I will expect everyone to exercise a spirit of reasonableness in their undertaking, in their business as well. So, yep, it's all looking into the agreement and also between negotiation between parties.
Yes. I think this is very much related to our last talks pertaining
Yeah.
to the force.
Yes, Jason. I think when a such situation occurs, I think the clause force major will comes in, because now during the COVID-19 the clause force major is where rarely has been interpreted, has been rarely a lot of people are looking into it, because all the while the force major was could be a default clause, but all the while did not serve much purpose for most of the contracts. But at this juncture, because COVID-19 is totally took a toll on everyone, the clause force major comes in. And plus, like what just to add on what Mr. Paul said, it's just between will be a usually it'll be a negotiation between the parties. How do they want to enforce the contract? Whether the force major will comes in when then leads to negotiations.
Yes,
Yes, thank you.
sorry if I may.
Yes, Mr.
Sorry if I
Dennis.
may
Yes,
add on a little into
yes,
all this great insight by these
yeah,
two folks. It's just that
yeah.
another thing is that you have to look at the wording of the clause itself. Does
Mm,
this COVID-19 is it cover? I think it was discussed earlier last week or 2 weeks ago during the discussion on the force major clause. Does the word
yeah.
pandemic does it encompass this current crisis of COVID-19? So the wording of the clause have to be taken into account, have to go into details.
Yes,
Yes.
correct.
Just to add on to what Mr. Denny said, if either one
Yes.
of the parties is unhappy with the wording of force major, just say one party say no, we are not. We're going to proceed as the winding up as it is, since the force major does not cover the word of COVID-19 epidemic or pandemic or disease. So
Yes.
then that is burden on the particular party to challenge the words of the challenge dispute of the agreement force major will be lead to the court.
Yes.
Or if there's a one situation where it'll take a troll, will take a longer time for them to decide, because the interpretation could be a wide, and that's the best place is only the court to judge whether it covers this. And further, just say in any agreement, that's a repetitive of the last occasion. If there's no any force measures been included in the agreement, with the consent of both parties, they can do a supplementary agreement by adding this word force major. Then it
Mm,
might resolve the issues that they are looking into it.
yeah. Yeah. I think. Thank you very much, Mr. Dennis and Mr. Satya. I think this question is very good and also very widely interrelated to many people out there. Whether you are, the last week we talked about how does it related contract out there pertaining to signing of the SMP sales and purchase agreement, or whether it's the tenancy agreement or any other contract, uh, as the case may be, it is also related to this. Due to this unprecedented crisis or pandemic happened in Malaysia, I believe many, what Mr. Dennis have pointed out, very important, that we have to really look at the interpretations of the COVID-19 pandemic situations or any other disease per se that affect the changes of law during the very first time when when the country locked down during the MCO period. A lot of businesses cannot be operate. You know that it is a direct hit or direct affected the most of the SME and so on. So it is really much trigger the tenancy agreements and any other commitment between the parties, whether it's business agreement, joint venture, and so on. So I think I think the panel have actually pointed out there are several ways. Of course, you have to start looking at the contract, and moving on from there, a negotiation can take place between the parties as well. Because this is pretty much unprecedented, and it's no fault of one party as well. Yeah. Okay. If moving on to this, the questions we come to the point that we will be ending soon on our talks, perhaps I will just give a few minutes of every panel here to share a last word or last opinion or anything that you wanted to share. I mean, in conjunctions of the further CMCO will then be extended until 9th of June. Yeah. Maybe Dennis, you want to get the ball rolling? Any last word from you before we end?
All right, thank you. It's just that one of the phrase that I think stated by Mr. Paul is that this spirit of reasonableness, it has to be instilled in everyone. Everyone has to be just like one of the questions just now. You can't put a specific time frame on where does the agreement to begin or to end. So even this includes the inclusive of the undertaking as well. So everyone has to be reasonable on how and to be patient throughout this ordeal.
All right. Thank you, Mr. Dennis. All right, Mr. Paul?
I still just like to say that be safe. Try to maintain social distancing as well. Even now it's extended. I think it's good for everyone. Just for the sake of our health. So maintain social distancing. Then we try to persevere and go through this all together.
Thank you, Mr. Paul. Thank you. Mr. Satya?
I would say in Malaysia, the CMCO has been extended. It's for us to take care of our own self. In Malay, they will say, kita jaga kita now. So,
Right.
Mr. Paul and Mr. Dennis said, so we should distance ourselves and each of us have to take care of our own self. Each of the citizens have to play their own role. So that will be a corporate enough to combat with to battle with the COVID-19. Thank you, Mr. Jason.
Thank you, Mr. Satya. And attending the sessions. Perhaps I just giving out a little bit of briefing pertaining to our talks. Probably there are some new members or new friends are joining us today. Basically, it is an initiative taken by the lawyers today. Trying to reach out. During the lockdown time, lawyers are being captured into four walls, and we're trying to reach out, and we think that we can act a bit on our part in terms of community service, and that's why we try to reach out today. From time to time, we will then have several different topics in hot topics in the society. The people will then start talking about, though we have covered a few topics already in the past. For friends out there, you can actually visit our website or visit our Facebook page and scroll down all the past video that we have captured. Can actually look through it. From time to the panel will then sit down and discuss. Yeah. So, okay, we wish everyone all the best and stay safe. Okay, we'll just end here today. Thank you very much, everyone, for joining us.
Thanks for having me.
See you.
Guys.
All right.
Everyone, thank you for all the viewers and my friends from abroad who are watching this video.
See.
Thank you.
Thank you.
Guys.
Yeah. Thank you. Bye.
Thank you.
Bye.